Morning, honorable members and our guests in today's meeting.
Recording in progress.
We have two presentations that we are to receive today. What we will then do, because I don't want to waste much of our time, because we are competing with load shedding, maybe some of us. We will then request Mr. Sakaza to do the House rules in terms of taking us through the attendance register for our meeting. Over to you, Mr. Sakaza.
Good morning, Chair, and good morning to the members of the Portfolio Committee, the Department, CGE, and the Registrar. Chair, we have today the following members. We've got Honorable Chair Dunjwa, Honorable Nonsele, Honorable Ndabe, Honorable Zuma, Honorable Mkonto, Honorable Denner, Honorable Kado, Honorable Begren. Earlier on, Chair, I did see Honorable Volmarans, but I don't know whether he's having a trouble because he also he left the platform. Maybe he has a problem, but he's not here now. Chair, from the staff, we've got myself, we've got Poshi Antabeni, we've got Kolelwa Mabindisa, Tebuho Mkwena, Sibongiseni Ngobo. In terms of apologies, Chair, I've received from the Deputy Minister and from the Minister. Deputy is in Cabinet and Minister Nglesi is in ILO Geneva attending there. I've also been told that Dr. Muyemi is the acting DG Chair. Thank you for my side, Chair. I see Honorable Likov also joining, Chair. Thank you.
Hi, introduce the department. Solan. Can we then check from the department who is here? I see who is here from the department. Who's going to assist us? Who's assisting from the department?
Good morning, Honorable Chair.
Yes, who's talking?
Chair, my name is Alec Moemi. I'm the acting DG at the department.
Oh yes, welcome. You will introduce you'll introduce your team.
Indeed, I'm with the special advisor to the Honorable Minister, Mr. Lumko Mtimde, and I'm also with Ms. Ongem Jo, who is the Chief of Staff for the Minister. From the department, I'm with Mr. Tembinko Simkalipi. I'm also with Mr. Tando Wababa, and also with Ms. Matapelo Mataboke from my office. These are the colleagues that are joining us from the department this morning.
Thank you very much. But I would have thought that you also have to introduce the registrar, because he's part of the department, independent as he is. But he is.
Yeah, I thought so, Chair. I thought so, Chair, that because of what you've just said now, the independence of the registrar, that I took it for granted. My apologies, Chair, that you were going to then go to the registrar and ask Mr. Ltono Mlefe to introduce himself as well as who he may be accompanying him.
Okay. Thank you. Our agenda, thank you very much. Welcome. Who else is in the meeting? That is not part of the department, no part of the committee. Mr. Sakaza, who has not been introduced. I see a number of people. Leanne van der Merwe, from where? Can those please introduce themselves?
Chair, that's the CGE team that I will introduce when you. It's our turn to introduce.
Oh, okay. Thank you, Advocate. Thank you very much. Thank you. We will then, because our agenda is that first is the presentation by the registrar, which then we will allow him to do that, and he will also. I will request Advocate Mohale to please mute your mic because it may disturb us. Okay, thank you. I will then request the registrar to put his presentation and also open his mic so that we see whom we are talking with, which he will then introduce. He or she will introduce the people that he is with. Over to you, Registrar.
Good morning, Honorable Chair and Honorable Committee members. My name is Leshonolo Mlefe. I am the Registrar of Labor Relations based at the Department of Employment and Labor. I am accompanied by 3 colleagues of mine. The first one is the Deputy Registrar, Ms. Mering Wejana. The second one is Mr. Javtatlo, an Assistant Director in the department. And the third one is Ms. Sistabohelo Mahlangu, an Assistant Director in the Registrar's Office. Thank you, Chair.
Thank you. You will then will allow you to table your presentation. And if the mic is going to disturb your network, it's fine. You can switch it off. We saw you. I don't want you to be disturbed by load shedding, not unless where you are comfortable that your network is stable. So if you can flight your presentation, that will be fine. Matapelo knows, yeah. Thank you.
Thank you, Chair. Thank you. As indicated, I'm the Registrar of Labor Relations. My presentation will be on the mandate and the functions of the Registrar of Labor Relations. In slide 1, the Registrar of Labor Relations is an official who is designated by the Minister to perform functions on the labor relations, and the Minister has also designated a Deputy Registrar who is tasked with assisting the Registrar in executing his mandate in terms of the Labor Relations Act. And slide 2. The Labor Relations Act in the relevant provisions had indicated that the Registrar and the Deputy Registrar are independent, subject to the Constitution and the law, and they must be impartial when exercising their responsibilities and must do such without fear nor favor. No organ or state may interfere with the functions of the registrar. These are all points that are captured in the Labor Relations Act. These are the amendments that were effected after a case that involved the former Registrar of Labor Relations and the former Minister of Employment and Labor. And slide 3. We give an overview of the functions of the Office of the Registrar of Labor Relations. We are responsible for registering trade unions and also keep the Registrar of Registered Trade Unions. We also responsible for registering employers' organizations, and we also keep a register of registered employers' organizations. We also keep a register of federations for trade unions, register for federations of employers' organizations, and also the registrar of bargaining councils. We also happen to register bargaining councils. And in slide 4, we had been requested to give a presentation on registered trade unions. But as you would have seen, honorable members and chair, that the registrar's responsibilities also include registration of employers' organizations and registration of bargaining council. For the purpose of this presentation, we will confine ourselves to trade unions. In terms of the sections, which is a definition provision in the LRA, defines a trade union as an association of employees whose criminal purpose is to regulate relations between employees and employers, including employers' organization. This is the foundation of what should be a trade union. The following slide, Honorable Chair and Honorable Members, gives us what are the requirements if someone or a union wants to apply to have a union registered. Any union may apply for registration of a union, and also in order to qualify, the requirements are clear that it has to adopt a name that complies with subsection 4 of the Labor Relations Act. It has to adopt a constitution that complies with subsection 5 and 6 of the LRA. It has to have an address in the Republic. It also has to be independent. Those are the statutory requirements. The registrar, in terms of section 96 subsection 1, may require further information in support of the application. A typical example would be we would require copies of identity documents. That is just one example. And in the next slide, the law is quite clear in terms of section 95, subsection 7 of the LRA, that the registrar must not register a trade union unless the registrar is satisfied that such an applicant is a genuine trade union as envisaged in the LRA. In order to establish the genuineness of a trade union, the registrar applies the guidelines for registration as gazetted by the Minister in consultation with NEDLAC in terms of the relevant provisions of the LRA. Now, the issue of genuineness. The guidelines are clear that the registrar must examine the activities of the trade union. One typical example is how the frequency of elections takes place within the organizations. Those are just one example, but there is a list of those examples outlined in the guidelines. What is expected of a registered trade union? A registered trade union must comply with Section 98, Section 99, Section 100 of the LRA. Section 98 speaks to the duty to audit. There is an obligation on the union to conduct audits on the subscription or agency fees that they are receiving. Section 99, there is a duty on trade unions to keep records. Section 100 of the LRA, there's a duty to provide such information to the registrar when the registrar requires such information. A registered trade union must comply with its certified constitution. The following slide, cancellation of registration of registered trade union. The cancellation of registered trade unions is provided in Section 106 of the LRA. The registrar may cancel registration of a registered trade union if the registrar is satisfied that the registered trade union is not or has ceased to function as a genuine trade union. The registered trade union has failed to comply with Section 98, Section 99, Section 100 of the LRA. You will recall, Honorable Chair and Honorable Members, in the slide before this one, there was a pointer what these provisions indicate what needs to be done by the registered trade union. The following slide, administration in terms of the LRA. This is a fairly new amendment in the LRA, Honorable Chair and Honorable Members. The registrar may invoke Section 103, capital A of the LRA by applying to the Labour Court to have a registered trade union placed under administration. The following slide. Administration in terms of the LRA. In terms of the relevant provisions of the LRA, the Labour Court may order that a suitable person who may be a commissioner to be appointed to be an administrator of the registered trade union, as may the court determine fit and satisfy that it is just and equitable to give such an order. What this simply means, Honorable Chair and Honorable Committee members, is that the registrar has to approach the court to have a trade union placed under administration. And the candidate has to be identified, which is what we've been doing since the amendment has taken place. We've been interviewing candidates to determine their suitability. Once the candidate has been appointed, he becomes an officer of court. With that order that appoints the administrator, there is terms of reference what the administrator should be doing in order to execute the mandate that the administrator has been granted by the court. The following slide there are conditions that must be satisfied to enable for the registrar to approach the court to place a union under administration. You will recall, Honorable Chair and honorable members, I stated in the previous slide that it must be just and equitable to do so. The registered trade union, if it has failed materially to perform its function, that is one ground. Where there is serious financial mismanagement, that is another ground to place a union under administration. The following slide. The administrator, as we know, will be executing a mandate that the administrator would have been given by the court. The registrar of the labor court, not the registrar of labor relations, is the one that determines the fees of the administrator. So there is a determination that is issued by the registrar of the labor court that outlines what the administrator can claim as and when he or she executes his duties. The administrator's fees will be paid at the expense of the registered trade union. The following slide. Thank you very much, Honorable Chair and honorable members, for the opportunity that you have given us to be able to give this presentation. Thank you very much, Chair.
Thank you very much, Registrar. Honorable members, there is the presentation, which has also been circulated to us. I will then check with members if are there any clarities, questions, and comments. But I want to remind members that the registrar is independent of the ministry. So whoever is here from the department is not expected to answer questions because of precisely that that office is independent from that. Even as much as I will, the accounting officer is there's that interaction, but we will expect responses from the registrar and his team. I'm just checking if are there any hands. There are two hands, Honorable Kondo, Honorable Mudabe, in that order for now. Honorable Mkondo.
Thank you, Chair. Good morning, Chair, to you, honorable members, the minister and his team, and the acting DG. Chair, I will start by welcoming the acting DG. We hope he's here to improve the performance of the department. Chair, also greetings to Mr. Mlifi, the registrar and his team. Chair, I have few questions. I think Mr. Mlifi will understand that as members of this portfolio committee, if there are things that are happening related to labor issues? Can it be in relation to him as the registrar or the department or the unions or whoever as elected representatives of the people? They always complain to us. So he has to understand that before I start with my questions, because my questions, some of them will be from the people that constantly complain to us as members of parliament about the institution that he is leading. Chair, my first question would be, how long should a union be put under admin? And who evaluates the performance of the administrator? And who has powers to remove the administrator if there are signs of incompetence, or if there are signs of him or her being conflicted, or if there is any abuse of powers in relation of maybe administration or finances? So, and who determines the salary of the admin? Mr. Mlifi said the union under administration is responsible for the salary of the administrator. And then who determines the salary? What powers are left with the democratically elected members of the union if the union is put under administration? And if it happens that the union is deregistered, what happens to their investment companies? I think for now, Chair, those are the questions that I'm having for Mr. Mlifi and his team. Thank you.
Thank you, Honorable Konto. I forgot to just inform Mr. Mlifi that members will ask questions, and then when they are done with asking, when we're finished with asking questions, you will then respond. So please have your pen and paper so that you jot down all our questions. The next questions will be asked by Honorable Mdabe.
Thank you very much, Honorable Chairperson. Good morning to yourself, honorable members, all the staff from the Parliament, as well as the department, registrar, as well as all other presenters that are present in the meeting. Thank you, Chair, for the opportunity. Partly covered by some of the questions by Honorable Mkonto. I'm left with at least two. One is in relation to where there is a challenge in the union that out of its functionality and systems and processes, there is an outcry whereby then you would find that maybe there are then two leadership structures of a union. The union is registered, however, based on the challenges and its functionality or dysfunctionality, then it ends up having two structures that run that particular organization. What role, therefore, does the registrar play in that situation, if ever the law does allow? What are the ramifications in terms of the functionality thereof of two possible structures of a particular union? The second question is, if therefore then the union has been deregistered or is under administration, let me put it that way, the role of the administrator in terms of then the functionality of the union in representing workers where they have challenges? Those are the two questions, Chair. I'm partly covered with some of the questions that Honorable Mkondo raised. Thank you.
Honorable Nonsele?
Thanks.
Oh. No, I thought you were cut off. Fine, you may continue.
Thank you, Honorable Chair. Good morning to yourself and the honorable members. Good morning to the registrar and his team, the department led by the acting chief DG, and our guests. Chair, I would say, in a way, some of the questions indeed they have been covered by the earlier speakers, but there are specific questions that I would want to raise to the registrar. Perhaps in a different format. The first one is with regard to the appointment of the administrator. The question would be what roles regulate his or her conduct? Because when the registrar was presenting, he didn't say that a union, by virtue of being put with a registrar, its constitution is suspended. If then it is suspended, what rules then regulate the union, and how do the administrator apply his or her rules? In what way? The second point that I want to understand, Chair, perhaps also it is linked to what earlier on was raised by Honorable Mkondo, is with regard to the projects of the union. As we understand that the act, that is the LRA, is amended, imposes obligation on the union, particularly with regard to the role of members. What becomes the role of members? I would say, for instance, you have a situation in a union called SPAO, where the registrar has, by virtue of her powers, dissolved structures. Where do those powers by the registrar are derived from? Because certainly the union constitution does set out clearly what steps should be followed in terms of removing and changing structures. The third question would be the sounding board or lines of accountability for the registrar, who then sits and concurs with the registrar on whatever his or her actions are going to be taken. And the last question, Chair, again goes back to the investment company of SPAO. How does the administrator appointed exercise powers in an investment company of a union? Does the administrator have powers to override the board of directors or whatever structure that has been set by the union? There are serious allegations, Honorable Chair, that have been made against the registrar. Both the one that came in earlier on, who in fact demanded a sum of about 7 million from the union investment company, and then ran whatever he or she meant to do, but quite strangely paid a former general secretary of the union an amount of 1.5 million. That's the allegation. The second allegation is that the administrator was appointed after the earlier one, was removed, again demanded from the investment company. And when he or she was asked to submit a budget, and then there was a deadlock because the union or the administrators of the investment company insisted that the administrator must first submit a budget, and therefore they would allocate as per the needs of the program, rather than to allocate a particular amount. We're raising these points, Honorable Chair, because we need clarity from them, because there's a serious allegation that impairs the integrity of this independent institution. So if the registrar can help us understand how the registrars derive the powers to go and make such serious decisions. Yeah, is it based on the law or the powers that are vested with the administrators? If not, where are these powers derived from? Thank you, Honorable Chair.
Thank you, Honorable Nomsele. From my side, is just one clarity that I would sort. There are a number of trade unions, some of them which are independent trade unions, which they don't fall. They don't have any federation. A number of them. Them in different federations and independent. Does this office have a, okay, let me rephrase. How then do you monitor? How then do you monitor if all unions are conducting their business as prescribed by the Labor Relations Act? I'm asking that question because I'm seated here. I'm just visualizing the number of trade unions that are there. As I've said, others, they fall under federations, others are independent. How do you monitor so that you are able to pick up if there are those that are not run according to the prescript of the labor relations, and which unfortunately will then end up in workers being run by, if I can say, by a fraudulent person who is just taking their money. And so it's my concern, my clarity is on that in terms of do you have a system to track and monitor all trade unions, or you only come in when there is a problem? I'm assuming, you'll correct me, when then there will be a problem, you only come in. I think a case in point here, as Honorable Nonsele have said, that is a quite, and you must understand, as Honorable Mkondo have said, that we are, by virtue of being members of parliament, a number of workers and leaders thereof they will come and request Parliament to intervene, but you will understand that Parliament hasn't got those powers of intervening. That's why there are statutes and there are entities that are governed by those statutes, and some of the queries and complaints and cries that come to us as members of parliament are coming from workers and ordinary. So us calling you here, among others, is to empower us so that we really understand what then becomes your role working together with the Department of Employment and Labor. So I will then hand over to you to respond.
No,
over to you.
can I answer, Honorable Chair?
Yes, over to you. You may answer. You may respond to our question.
No, thank you very much. Thank you very much, Honorable Chair and honorable members. Maybe I must just indicate that I heard Honorable Mkondo saying that I must understand where they're coming from, why these questions are being posed. And I just want to say that that's precisely the reason why I took a decision to avail myself, because I'm fairly aware of the accusation that are out there about how the registrar office operates. And unfortunately, the registrar has not had that opportunity to explain or even clarify some of the issues that are being articulated. So hence, I am here, and honorable members and honorable chair, you can ask me any question that you want to ask me. I will answer to the best of my ability. I am a public servant. I have a statutory obligation to the country that I belong to. There is nothing hidden. So hence, I availed myself so that I can answer these questions. The first questions that I got was from Honorable Kondo. How long is an administration supposed to be? Each case is determined on its merits, Honorable Kondo. What do I mean when I say that? Let me give you a practical examples that we've had of trade unions that were in administration and some who are in administration. One example would be a case that is Sama NPC versus Samadu. The union was placed under administration because there was an overlap between what the union was doing and what the NPC was doing. And as a result of that, the union of medical doctors was hijacked by the company registered under the Companies Act. That administration, if you look at the number of members that belong to that particular trade union, it's about 7,000 members who belong to Samadu as a trade union. I can give you roughly how long it took for that administration to complete. It took 3 years for the administrator to complete that administration. You might ask yourself, why 3 years? When you deal with trade unions, in this case with a private company, they have muscle to litigate against the administrator. And in doing that, it prolongs the administrator from completing his responsibilities as mandated by the court. An example, in that very same case, you had a private company that took about 300 million of workers' money and claimed that this money belongs to a private company. There had to be forensic investigators that had to be appointed by the administrator so that the administrator is in a position to determine what belongs to the union, what belongs to the private company. That is one example of how complex administration is under the LRA. Second example, You will recall I said each case must be determined on its own merits. You will have cases where a union is placed under administration for failure to hold a national congress. You would agree with me, Honorable Chair and honorable members, these two cases are not the same. All that the administrator has to do in this one case is to arrange a congress. Obviously, the term of the administrator will be less as opposed to an administrator who has to separate assets that belong to a union and those that belong to NPC. So that is my response to the first question. The second question, who evaluates the performance of the administrator? The administrator, when appointed, you will recall I made reference to terms of reference. Those terms of reference become part of the court order that the administrator is tasked by the court to execute that particular mandate. The administrator has to report on a monthly basis to the registrar. Bear in mind, I said in my presentation, the administrator, when appointed by the court, he becomes an officer of the court. If there are any issues of concern that the registrar will pick up from the reports that are submitted by the registrar, by the administrator, I can't just remove an administrator. I have to approach the court and say to the court, court, you have appointed this administrator. Here are issues of concern that we want to bring to your attention. And then the court will analyze that information. If the court agrees with our submission as the registrar, will remove the administrator. If the court does not agree with our submission, the court can say, registrar, you are wrong, the administrator stays. In essence, what I am saying, Honorable Chair and honorable members, supervision of the administrator, because he's a court-appointed officer, it's the labor court. There is case law to that effect. If at the right opportunity, I will print out all case laws that speaks in particular with the issue of administration. These cases have moved from the labor court, labor appeal court, including the Constitutional Court has agreed with that position. So in short, it is the labor court that supervises the administrator. The third point, who determines the fees of the administrator? You will recall, Honorable Chair and honorable members, when I gave my presentation, I made reference to who determines the fees of the administrator. It's in the law. The law says the fees of the administrator are determined by the registrar of the labor court. There is just an unfortunate misrepresentation in regard to that, because some feel that the registrar of labor relations should be the one. The law does not say that. The law says it is the registrar of the labor court that determines the fees. The fourth point is the powers. The powers of the democratically elected structures of the union. Again, there is case law to this, Honorable Chair, honorable members. We will supply you with this. When a union is placed under administration, The law is quite clear. The administrator assumes all powers and responsibilities in terms of executing the mandate that is in the Constitution of the Union. So in essence, what this means is that nothing happens in the Union without the approval of the administrator. There is case law to this effect. We will print out all these cases. As I have indicated, that these cases have ended up in the Constitutional Court, and the Constitutional Court confirmed the position that the administrator, when appointed, assumes all responsibilities and powers. The last point, Honorable Chair and honorable members, is the issue of the investment. Apologies about that, Honorable Chair and honorable members. The last question, if I understood correctly, Honorable Mkondo, you were making reference to the investment. As far as I understand, your question is whether the administrator has got authority over the investment. You correct me if I've missed the point. In terms of the order that appoints the administrator, you will see that there is a list of powers that the administrator has. I'll just name one, but again, we will supply the honorable committee with those cases. One of them is the administrator is tasked with the responsibility of investigating financial irregularities. And where financial irregularities have been found, he has a responsibility to report those irregularities to the law enforcement agencies. Secondly, in terms of the terms of reference, he is also, or she is authorized to take control of the investments that belongs to the union. Those are clearly outlined in the terms of reference when the administrator is appointed. Going to Honorable Ndwabe. Your question was around if there are two factions in an organization, what is the role of the registrar in that regard? You will recall in my presentation, I had indicated that the registrar, in terms of the law, is supposed to be independent and impartial. And we do not allow ourselves to be drawn into internal disputes of factions in a union. Our focus is on compliance in terms of the Constitution and compliance in terms of the LRA. There is a very interesting case at the Labor Court where Judge Van Niekerk had indicated this very same point, that registrars don't get involved in the disputes that are happening in a union. You are supposed to be impartial. Your focus should be on whether they are complying with their constitution or they are complying with the relevant provisions of the LRA. So we do not get involved because of knowing that once we get involved, either position that you take, you will be accused of siding with the other. So our focus is compliance, compliance, and compliance.
Are you still with us?
My apologies, Honorable Chair and Honorable Members. The last question from Honorable Mwabe, if I understood you correctly again, was what happens to the investment if a union is deregistered? You will recall, Honorable Chair and Honorable members of the committee, when you talk of investment, it must be understood that it's regulated under a different legislative regime. An investment, it's a company. And you have a union registered under the Labor Relations Act. What happens to the investment? It will be a question of, once the union has been deregistered, the assets that would have been those of members will have to be dispersed to members, or in some instances, if, for example, a union is wind up, you will have instances where a liquidator will be appointed, and the liquidator will then be in the position to retrieve the investment that belongs to the union. The other questions, Honorable Chair, was from Honorable Nonzele. Appointment of administrators. Who appoints administrator? Let me clarify this position. We identify a candidate. We interview the candidate to determine suitability of the candidate. When we have identified a candidate, we propose to the court that this is the candidate that we could find, looking at what issues needs to be addressed by the administrator. If the court agrees that this is the right candidate, the court will appoint the administrator. If the court does not agree that this is not the right candidate, the court will reject the candidate. We have not yet had a situation where we have nominated a candidate and the court has rejected that candidate. The second question is, what happens to the structures when a union is under administration? What essentially happens when a union is under administration, as I indicated earlier, the administrator takes full control of the affairs of the union. And then if there are structures, then those structures will then be the ones that the administrator will task with responsibilities in terms of the Constitution. The Constitution is not suspended. All that happens is that the powers that they had in terms of the Constitution of the Union are given to the administrator. Third point, accountability. If I understood very well the question, is who does the administrator account to in terms of the finances. Again, I'll go back to what I had indicated, honorable members and honorable chair. The administrator submits reports to the registrar on a monthly basis. If, as we peruse the reports of the administrator, we pick up discrepancies, we have to approach the court and make the court aware that there are these issues that we have picked up. And if the court is concerned about that, the court will then take the next step of removing the administrator. If the court does not agree with our view, the administrator will continue his or her work. And again, there's an issue of the investment. You see, I will say this, Honorable Chair, from our experience. And I'm happy that the issue of SEPAO comes up, because there's a lot that we can say about what is happening from what has been reported by the administrator. The investments, unfortunately, from our experience, not all of them, some of them have become a cancer for the trade unions. Some have gone to the extent of hijacking the unions. Let me go deeper. There is a report on the SEPAO case that has been posted by the administrators on the website of the union for members to see. It is jaw-dropping what is contained in that report. One example that I can mention, in that report, 10 billion of workers' money has disappeared from SEPAO. 10 billion. No one knows what has happened to workers' money. Is that acceptable? That should never be acceptable in any form. And when you look at the challenges that SEPAO is confronted with, from what we see and from the reports that we've been receiving, the investment of SEPAO is at the center of this problem. This report that is in the website of the union that the administrators have given to us implicates individuals by name in that report. The report was released in 2021. If any of the individuals or companies implicated in that report did not agree with that report, they would have taken that report on review to have it set aside. And guess what, Honorable Chair, Honorable members? As far as we are aware, not a single individual has contested the contents of that report. And papers, court papers that have been filed by the administrator in the Labor Court, in the Labor Appeals Court, and in the Constitutional Court, the administrator makes a serious allegation and says the investment attorney had indicated to him that we are the ones who are destabilizing this administration. You know why, Honorable Chair, Honorable members? You recall I have said in one point that I raised, one of the tasks of the administrator is to investigate financial irregularities And where there are financial irregularities, there is a responsibility on that administrator to report that to the law enforcement agencies. So that's where we are on the Sepao case. I'm happy that it comes up like this because there is a need to clarify a whole range of issues around the Sepao issue. The other point, Honorable Chair, there's an issue that the administrator, I'm not sure now which administrator demanded 7 million because Sepao has two administrators. The first administrator had completed a mandate, which was to finalize audits, and she left. We have now the other administrator who is tasked with the responsibility of preparing the union for Congress. So we're not sure who between these administrators has approached the investment to demand 7 million. But here is what we know. From the reports of the administrator was that there was a loan agreement that was signed between the administrator and the investment company. If my memory serves me well, was that the loan was about 40 million. And along the way, there were disputes between the administrator and the investment. And when there was a dispute, I received a letter from the investment saying that I must get involved in the dispute. Here is my problem with that approach. We all know that a loan agreement has got terms and conditions. If one party has defaulted in terms of the terms and conditions of that agreement, which by the way, we were not even invited, we just reported on that there is a loan agreement. And then now that there is a dispute, we must come in. And the first thing we had a problem with is that on what basis do we come in when there's a loan agreement between two parties? And we are not contractors to that agreement. And we know that there's a breach clause in each agreement should any of the parties default in terms of that agreement. They've got the right, the recourse to approach the court and enforce that agreement. So that part of 7 million, we might just need clarity around because we're not sure who is it, but that is my understanding of what transpired. And I'm assuming that the administrator that is being referred to is the first administrator, Ms. Mashanda, because from the reports that I have received, the second administrator has not received anything from the investment. That is my little bit of knowledge that I got from the reports. The other questions is from the Honorable Chair. Honorable Chair, I must just say that it is a huge task and responsibility that we are sitting with as the Registrar's Office. And I'll give you an example of what do I mean when I say this. Currently, we're sitting with 214 registered trade unions, 146 employers' organizations, and 46 bargaining councils, and 2 statutory councils. The task that we have, we try our best. So in terms of monitoring, we do go out to check if unions are still operating. We do write letters to remind them on their compliance status. And in some instances, we do call them in and address the concerns that we would have with that particular union. I'm not sure, Chair, if I have responded to all the questions, but I will pause for now. Thank you, Chair.
Yes, I think you have responded to all the questions, which some of them are raising some challenges. Unfortunately, there is another presentation that we are to receive. But for me, I've got just Honorable Mkondo.
Chair, before you make your closing remarks on this matter, can you allow me to make a comment, please?
Okay, you may. Why do you assume that I was going to make a closing remarks? All the same,
no, I don't want to speak.
It's okay, Honorable.
You, Chair.
I'm not quite sure. No, it's fine. It's fine. Honorable Nonsale, is that a legacy hand?
It's a new one, Chair, Honorable.
Okay, Honorable Nonsale.
Chair, I think we have to be given documents as promised by Mr. Mlife, in as far as the issues of SEPAU are concerned. And another thing, Chair, I did not hear the response in relation to the 1.5 million that was given to the former SG of SEPAU. I know, Chair, maybe he doesn't have the answer now, but if, Chair, we can be given even the reports that the investigative reports that he's saying is on the website of the union by the registrar and so forth. I think that will assist us to understand fully as to what is going on, and maybe the progress report of the registrar that is there. Maybe not in details, but just for us to understand as to exactly what is going on in SEPAU. Thanks, Chair.
Thank you, Honorable Nonsale.
Thank you, Honorable Chair. I think Honorable Mkondo has read my mind, because I was going to put the same proposal that we perhaps would be in a better position, Honorable Chair, if we can be supplied with all the documentation that relates to this matter. As you may note that there is no dispute that there is money that has changed hands. The only dispute is about the actual amounts, because the registrar is speaking about 40 million, and I'm speaking about less, which is 7 million. So meaning that indeed we need to go into detail so that we understand exactly where the problem is, and that when these complaints are coming to us, we are able to be in a better informed position from both sides. That is the office of the registrar and those who are complaining from the union side. Similarly, Chair, I would add that the reports that should be submitted would include also the one that is placed on the website of the union, so that we have a comprehensive view of everything that comes from the side of the administrator. I think the name by the registrar, I think he is correct, because the accusation indeed are in fact directed to the first administrator in particular. There could be slight reference to the second one, but I think more significantly, the first one is the one that is alleged to have made whatever the registrar has since acknowledged in terms of whatever arrangement. The final point, Chair, is to say perhaps it would be also be helpful when I'm not making conclusion for you, Chair, but a concluding proposal that we in fact agree that or commit the register that where there is a need to make a follow-up engagement on the matter, that he should at least as he has done, accord that opportunity to again hear from him. Thank you, Honorable Chair.
Thank you. From my side, I was going to ask a question in terms of the loan, which was made by whoever administrator, whether the previous one. Does the law allow the administrator to do that? To make a loan from the very same institution, entity, in this case, investment company of a union that he or she is to administer. Does the law, didn't you, as the officer of the registrar, find that a bit amiss, if I may ask? That's the question that I was going to ask before I then make a concluding remarks after you have responded to this last question, with an understanding that some of the information that we may be requesting, you will know better. You're the one who is more empowered in terms of law, that there may be an information that is not to be circulated because of APCT. There may be there is one that you have directed us to. Yeah, I just wanted to make that comment so that you don't go outside and then ourselves also being found to be, what is the term? Law overreach, whatever. So if you can respond to those comments and questions, the question that I have asked, then we will round up. And please,
thank you very much.
Hoping that you won't be long. Yeah, I hope by half past we must be done with you. Okay.
I promise, Chair, I won't be long.
You may.
Well, Chair,
okay.
The first question, if I understand it correctly, Honorable Chair, can an administrator get a loan? The terms of reference do make it clearly that the administrator has got authority to go and borrow money on behalf of the union. So it's there, it's in the terms of reference. The issue of can the administrator go and have a loan with the investment is a question that we've been asking ourselves also. Because for us, in any event, it doesn't make sense that I should go and borrow my own money. Because the investment that is for SEPAW, the money that is held by investment belongs to members. So even for us, it did not make sense. How can the administrator now be told that he must sign a loan agreement? But from the reports that we had received with the administrator was that the investment lawyers were insisting that there should be a loan agreement between the investment and the union. Not sure if I've answered you, Chair.
Well, okay. Maybe at another time, as Honorable Nonsele has made a proposal that maybe there's a follow-up, there will be a need for us to have a follow-up meeting, because there are some issues that we'll then need to get more clarity on, because I don't want to take time for the next presentation, and we have got a plenary to attend. So can we agree that the information that we have requested, you will then submit to the committee section, and some of the questions Because my question was more, I thought that was a personal loan. If I understood you correctly, it seems as if it's a loan that was made on behalf of the union. Maybe that you will clarify that when we see when we can call you again. Because you must remember, as I'm saying, as members have said, we are asked every time, what is the situation? How can we intervene? Can we intervene? And unfortunately, we can't intervene as Parliament, but we are to refer the matter to entities that deals with the issues concerned. I would also want circulate us with some of the case studies that you have referred to. And if there is another union that has got a similar challenge in terms of the situation of SAPAO, if it's possible, so that we're able to really have an understanding what is it that workers' money are faced with. Because remember that we are oversighting the department. You are a registrar that is independent. Obviously, you can't be independent from us. That is why we have called you. That is why we consulted that he is independent. Can we call him? And we were told, no, we've got the right to call anybody to come and clarify some of the matters in front of the committee, so that as we move forward, it's also our responsibility to say to the department, we have looked into this, what has happened, why was the register said to be independent, blah, 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 because this is quite broader and heavier than what is seen by the naked eye, because it involves monies of union. You can imagine 800 billion alleged to have disappeared. We haven't seen, there's 100 billion monies that workers have entrusted at the union. So to invest for their benefit. No, I thank you very much, Mr. Molefe. We will, as members, we'll look into some of the questions. There's a question that has been asked by Honorable Mugabe, which I still want to have a follow-up. But in the next interaction that we'll be having with you in terms of that question, I have flagged that question. That question that he asked is quite very important, and I'm a bit puzzled I'm a bit confused or surprised by a response that you gave, because that touches to the working and the nature of the unions. When there are two splits, of the union, who controls that money? If there are two, if union is split, there are other members here. As much as court said you must not be involved in that, but it's quite so. Let's thank you very much for coming. It's been an eye-opening session for us, and then when we sit as the committee again, we will then have to we're going to check before we close this meeting here to what it is. Members, there was that proposal by Honorable Nontsele that we will need to call again the registrar for a follow-up meeting and the clarification of some of the questions that are quite critical and crucial to be responded to. Do we have a seconder for that motion?
Sibusiso Mdabe, Chair, I do
We must, we have a second
second.
the motion that we must call the registrar again. Thank you very much, Honorable Mdabe.
Sibusiso
I don't
Mdabe,
think
Chair,
there's
I do
anybody who
second.
is. Thank you very much, Honorable Mdabe. I don't think, is there somebody who has got a different view on that? None. We will then give you the another notice on how to on when are you to come back and clarify some of the issues that we have raised. Thank you very much. You are released. And anybody from the department is not released, because the next presentation is also talking to, is a presentation that we wanted the CGE to come and tell us and expose us to some of the things and the work that they are doing, and which then touches into some of our work that we are doing as this portfolio committee. But the registrar and his team is released, and the department will decide who's going to be left behind. So it's only the registrar that is released from this. Thank you very much, Registrar. Now,
Thank you very much, Chair, members.
Okay, thank you. We will now invite Advocate Mofale, who is from CGE. You will introduce your team, and then we will then ask questions as we will then be interacting with your presentation. I will my apologies to you, Registrar, but we will then give you 30 minutes to 45 if it's fine with you. But yeah, no, thank you very much. You can then, the platform is yours. I don't know who is going to assist you to, whether you've got sharing powers.
I think, okay, thank you, Honorable Dunjo. Our presentation is going to be done by two of our senior members at the CGE. But before I go there, let me introduce my team. I am leading the delegation today. I am with another commissioner, Commissioner Lee van der Merwe. That's the person you were asking, that you're seeing other people in the meeting. Who are they? I'm with her as a commissioner. Other commissioners could unfortunately not join us today due to CGE work-related commitments, but there's two of us. And then we are with our team of legal and the head of research, who will be doing the report. Our acting HOD for legal is Mr. Tsietsi Shuping. He's the one who's going to do the transformation reports. And then we've got HOD of research, who is going to be doing the missing pieces on the NSP report. They are not alone. We have got Miss Liandi Yesthazen, who is our legal officer in the Free State, and Miss Tembi Madaleni, who is our legal officer in the Eastern Cape. They are with us as part of the team. Just before we start, I just want to explain that Dr. Matotoka is going to be joining us anytime now. He was in an examination up until now. So as soon as he's done, he will be joining. But we have got two very able staff members who will take us through the reports. Dr. Twalo, you are going to start as per the agenda. Please go ahead. Thank you.
Excuse me. Thanks a lot, Chair, and good morning,
Can
Honorable
you see your
Chair.
face, please?
Trying to do that. Okay, yes.
Okay. And are you going?
Yeah, I'm
you will
sharing.
be able to share. Okay. If then
Yes.
that you will switch off your video. We have seen you because I don't. Okay.
All right. Thank you so much. Can you just confirm if you can see my presentation?
Yes, I can see on my side.
Okay.
Yes, we can see it. Yes.
All right. Thank you. Thank you so much. Right. The report I'm presenting is titled Missing Pieces of the Puzzle, CGE's assessment of the government's implementation of the National Strategic Plan on Gender-Based Violence and Femicide between 2020 and 2022. With respect to our mandate, as the Commission for Gender Equality, we are an independent statutory body established with other Chapter 9 institutions in terms of Section 181 of the Constitution. And our mandate is also provided for in terms of the CGE Act as amended. And lastly, our mandate is to promote respect for, protection and development and attainment of gender equality and make recommendations on any legislation affecting the status of women. Section 11A stipulates that the Commission shall monitor and evaluate policies and practices of organs of state at any level, statutory bodies, functionaries, public bodies and authorities, and private businesses, enterprises and institutions in order to promote gender equality and may make recommendations that the Commission deems necessary. The study that we undertook, its main purpose was to review the implementation of the National Strategic Plan on Gender-Based Violence and Femicide by South African government and other state-funded entities between 2021 and 21-22 financial years. These were the first 2 years of the NSP implementation since it was formally adopted in 2020. The NSP was one of the deliverables as articulated by the Presidential Summit Declaration at the November 2018 summit. In terms of the background, the NSP provides a multi-sectoral, coherent strategic policy and programming framework to strengthen a coordinated national response to the scourge of GBV by the government of South Africa as well as the country as a whole. The strategy has a 10-year life cycle, 2020 to 2030, and was developed in 2019 through a comprehensive consultation process by the Interim Steering Committee on GBVF. The ISC comprises various stakeholders, including government departments, members of the civil society organizations, development partners, academics, and other role players. In terms of the methodology for this study, this was undertaken in one financial year, which is the last financial year, and that data was gathered from entities that submitted written responses to the CGE. So we wrote to the various government departments that were a part of the players in the NSP. And on the basis of those responses, we analyzed the data, which is what we will be presenting today. And we also made use of other sources, such as departmental reports, annual planning documents, and other unpublished documents just for triangulation purposes in terms of the data. The study limitations included the fact that we relied heavily on the cooperation of many lead and support government departments assigned tasks and responsibilities in the NSP. We, however, had a challenge with limited responses from government departments who were not in a position to offer updated progress information regarding the work done in terms of the implementation of the activities in the NSP. Some departments responded to the request for information on time, but with others it took rather long, and the quality of the information we received was rather not satisfactory in some cases, because it was scanty, and there was marked inconsistency with some of the responses. Most of the NSP targets are supposed to be achieved between 2020 and 2024, which is a challenge for the study, which was undertaken in the last financial year, because there were no annual milestones that we could use as a measurement for how far that particular activity is in terms of its implementation. So overall, this is how the performance is. There are 6 pillars that we looked at. There are targets that fall between 2020 and 2022. In this regard, there are 11 that were achieved, Pillar 1, Pillar 2, 4, and 5. And there were 5 targets falling within this period that were not achieved. I'll go into detail in terms of this. This is just to give an overall picture. So in terms of the progress of implementation for the 2020-2024 targets, there was progress detected in 72 of the activities, and there was no progress observed in 18 of the activities in the various pillars. And with respect to lack of information, this was a serious one in terms of our assessment of the performance of implementation. There were 38 indicators on which there was no performance indication. I will indicate as I'm going as to the causes for the various issues. The findings demonstrate that out of the 144 indicators, 11 that were targeted for completion within the 2020 and 2022 financial years were achieved. This category also incorporated indicators that were meant to be achieved quarterly and annually within the indicated periods. 5 of the 7 indicators falling within this category were unachieved at the end of 2022. 75 indicators with a rollout period of 5 years had some form of progress detected in their implementation, and the level of progress varies across indicators as discussed in the different sections regarding pillars. There was no progress detected on 15 indicators in relation to NSP implementation during the period under review. And the last category of indicators whereby performance indicators could not be achieved or could not be obtained, there were 38 of the 144 indicators that fall within this category. Regarding Pillar 1, which is about accountability, coordination, and leadership, the findings demonstrate that the National Council on Gender-Based Violence and Femicide as the accountability, coordination, and leadership structure was not established during the first 2 financial years rolling out of the implementation of the NSP. This was due to delays in the promulgation of legislation that gives existence to the structure. Like I indicated earlier on, the number of areas in which we could not get data was mostly to do with the establishment of the National Council on Gender-Based Violence and Femicide. And in such cases, it was then difficult to hold anyone accountable or to point out someone who may, or a department that may not have implemented that which was supposed to have been implemented because of the delay in this regard, meaning the establishment of the National Council. So the delay hampered progress on many indicators, particularly those wherein the council was assigned the lead role in the NSP, and the non-existence of the council also created an institutional vacuum on the overall oversight and monitoring of the NSP, given the gaps in data and information on the implementation of the various key activities that were supposed to have been achieved during the years under the review. So we could not assess key achievements and shortcomings under this key activity, and putting mechanisms and processes in place to hold state and societal leadership accountable for taking a firm stand against GBVF. So overall, the performance under assessment under Pillar 1 revealed that the advancements had been made to achieve some of the indicators. Pillar 2, which is about prevention and rebuilding social cohesion, we noted that there had been strides made on several areas under this pillar, such as the development of the comprehensive national GBVF prevention strategy. This is a comprehensive strategy taking a whole of society approach to addressing the root causes of gender-based violence and femicide. The strategy adopts a systematic approach and emphasizes the value of policy and evidence in driving an evidence-informed GBVF prevention strategy in the country. Other areas where progress was noted included the development of the National Integrated Prevention strategy against femicide, approval of the policy framework to address GBVF in the post-school education and training system, and the many communication interventions that were implemented. However, information could not be obtained on implementing several indicators, while progress could not be noted in some of the indicators. With respect to Pillar 3, which is about protection, safety, and justice, there was progress observed on the development of respective legislations, and these included the amendment of Chapter 6 of the Criminal Law, sexual offenses and related matters, the overhaul of the Criminal Procedure Act, the amendment of the Labor Relations Act, the finalization of Traditional Courts Bill, the inclusion of cyber violence in the Cyber Crimes Bill, which were all before Parliament for promulgation at the end of the review period. And the President had signed 3 bills into law: Criminal and Related Matters Act, Criminal Law, Sexual Offenses and Related Matters Amendment Act, Domestic Violence Amendment Act, and the signing of these laws is a significant milestone for survivors of GBVF in criminal justice system. And the amendment of the Customary Marriages Act has become law, and the regulations for sexual offenses courts were also finalized. So the Department of Justice and Institutional Development has thus proven to be able to implement Pillar 3 requirements, and SAPS, as the lead support department in the implementation of key activities, is also making strides in partnership with the Department of Justice as compared to other supporting departments. So progress with respect to the indicators is observable. However, there's a backlog with respect to DNA cases relating to GBVF, which is a key challenge under this pillar. Pillar 4, which is about response, care, support, and healing. The key activities under this pillar are mainly under the mandate of the Department of Social Development Department as the lead department. We had a challenge under this pillar because there were several indicators where progress could not be observed, and where the National Council was assigned the lead role, and this posed some serious setbacks, which translated to delays in terms of the number of activities that are supposed to have been implemented. And this was exacerbated by indicators where the National Council was assigned the lead role, and the role was not reassigned to any other entity in the interim while awaiting the establishment of the council. The progress relating to the passing of the Victim Support Services Bill is, however, one of the noteworthy progresses that were observed. And another highlight is the progress regarding ensuring government departments have employee wellness programs offering psychosocial services. However, the indicators were in no progress at all were under this pillar. These included the municipal plans on care and support, including a service map on referral paths for GBVF support services, substance abuse and related mental health care. And the second one is GBF programs with social workers that are institutionalized across the levels of schooling and higher education to provide caring and safe environments. So these are some wherein there was no progress observed. However, in spite of that, there's a considerable work that has been done and significant achievements made under the pillar. Pillar 5, which is about the economic power. Under this pillar, the pillar is centered on addressing women's economic marginalization, as women's lack of economic independence tends to entrap them in abusive relationships and prohibits them from reporting violence when it occurs. Key interventions in this regard include gender-sensitive budgeting, accelerating initiatives to address women's unequal economic and social positioning, making workplaces safe and violence-free for all women, and strategic policy interventions by the state, private sector, and other key sectors. While work was undertaken to implement this pillar, there's no significant progress that was noted across the indicators. There were, however, positive developments mainly noted on soft indicators, such as plans being put in place to introduce income generation projects. And the findings also indicate that the difficulty in achieving hard targets, such as the establishment of land and agrarian fund, interventions related to unpaid care work, and the development of the gender inequality index. And the strategies in this pillar recognize the clear link between gender-based violence and femicide and economic dependence, and seek to ensure that obstacles to women and vulnerable persons' economic autonomy are effectively addressed. The pillar strategies and interventions further highlight the need for supporting rural communities. The last pillar, pillar 6, research and information systems. This pillar plays a crucial role in the fight against GBVF by providing systematic information and data that can be used as evidence to coordinate effective responses to GBVF. The findings from the various indicators in this pillar show that notable progress has been made between 2020 and 2022. However, there's still room for improvement. There's a progress observed in conducting national GBVF prevalence study, and it is also important this is also important as it also looks into the extent of violence against LGBTQIA plus persons. It is commendable that such a study has been undertaken in South Africa as the country battles to collect, store, and disseminate reliable statistics on GBVF. The study will be crucial in providing data and information within each province regarding the context, problem areas, and challenges and scale of GBVF, which can greatly assist coordination between justice and crime sectors and social sectors in fighting GBVF. The study will also assist the National Council in having a baseline from which to work and coordinate its activities more systematically based on evidence. So on the basis of the findings, the CGE concludes that there is an indication of progress made towards achieving some of the indicators. There were several instances where progress could not be assessed due to lack of performance data. The lack of data undermined the objective of the review to give an overall impression of the strides made by the country and whether progress was achieved, was advanced, slow, or completely lacking in the implementation of the NSP. The other conclusion is that the delay in the establishment of the multi-sectoral national coordinating structure on GBVF has served as a major setback in the country's attempt to strengthen accountability and architecture to address GBVF adequately. And the lack of performance on information on the various indicators of the NSP points to the leadership and accountability vacuum created by delays in setting up of the National Council, as it is the entity earmarked to coordinate, lead, and monitor the implementation of NSP. And lastly, we conclude that effective operational coordination is necessary among institutions assigned the lead role and those assigned the support role on the same indicators to avoid fragmentation and to strengthen accountability among key institutions working towards a common goal. We therefore recommend that the process of establishing the council should be fast-tracked, as the effective implementation of the NSP is largely dependent on it. And we note that the findings demonstrate that while progress has been achieved on several indicators, the NSP costing has not been completed, and it is also unclear how the process is funded. The review covered weak and effective coordination mechanisms among lead and support entities assigned to the various key activities and indicators of the NSP. And we recommend that lead entities should play an effective role in ensuring coordination and accountability in the implementation of key activities where they are assigned. Thank you, Chair.
Thank you, Chairperson. I don't know if you want to take questions now or we go to the other report, then you can take all the questions at once. Chair?
Honorable Nonsede.
I'm here. I'm here. I'm messed up by the network. I'm here. Thank you. Thank you very much. Who is the next to present?
Okay. The next person who will present is Mr. Tsietsi Shuping. Mr. Shuping is our acting HOD for legal. He will present the two transformation reports. I'm just concerned about time, so he'll just club them together and then we can take questions thereafter. Thank you very much, Chair. Over
Thank
to
you
you,
very
Mr.
much,
Chair.
Advocate.
Thank you, Chair. If I may just confirm, the presentation is visible.
It is visible.
Yes, it is. Thank you.
Thank you, Chair. Thank you, Honorable Chair and Honorable Members. This is the presentation as per the request. This is the first report. It is titled the Report on Gender Transformation, Public and Private Sector. As the first part of the presentation, we will present on the following three departments that appeared before the Commission based on this report: the Department of Small Business Development, Water and Sanitation, and also Clover. The mandate of the Commission has been presented by Dr. Kutwalo already in the opening presentation, so I will skip the slide, Chair. The Commission resolved as in accordance with its mandate to conduct transformation during 2022-2023. Part of the objectives of these gender transformation hearings is to assess compliance with employment equity legislation, compliance with related policies, as well as assess compliance also with policies affecting persons with disability, women, and the previously disadvantaged. The companies indicated appeared before the Commission. We will start with the Department of Small Business Development. The department appeared before the Commission. Pursuant to engagement with the department, the following observations and findings were made by the Commission: that the information that was submitted accurately indicated an overrepresentation of Black men and Black women throughout the organization, especially at the top and senior management levels. As we are aware, Chair, that in terms of Section 195 of the Constitution, it states that the public service should be broadly representative of the Republic of South Africa. And also in a matter of solidarity and others, the Constitutional Court indicated that and confirmed that a broadly representative workforce cannot be achieved when an exclusive segment workforce exists. In this instance, there was overrepresentation of Black men and women to the exclusion of other races. The Commission also noted the department highlighted it as budget in achieving its transformation goals and did not have a gender-sensitive budget. The Commission noted the intention of the department to adjust its numerical targets so that it can address representation of other groups. Also, the Commission noted that the department envisaged that it will consult the Department of Labor in order to attract persons with disability. The department has not implemented its employment equity plan. Further, the Commission observed discrepancies in the manner that the department was procuring services. It indicated it has been experiencing challenges in inclusion of gender equality practices in its procurement cycle. Further, the Commission observed that the organizational policies that were submitted were not reviewed or were outdated. It is important to highlight, Chair, as a continuous exercise, the Commission always tracks the development of the legislation. At that time, the sexual harassment policy of the department was not aligned with the 2005 Code of Good Practice. And currently we have the Code of 2022, as a progressive means, the Commission continues to monitor these departments to ensure that their policies are updated as the developments are taking place. As such, at that time, the department's policies, they were outdated, and the recommendations were made by the Commission that it should review them accordingly. And the recommendations were therefore made to the department that it should address in ensuring that its employment equity, its plan has been implemented. As indicated regarding this, the case of Barnard, in the case of South African Police Service versus Solidarity on behalf of Barnard, the Constitutional Court indicated in that matter that the employer may refuse an appointment of a candidate who falls within a category of person that is already adequately represented at certain occupational levels. Despite this, Chair, departments are reluctant to utilize such judgments in ensuring that there is equitable representation through employment. And further, the department was recommended to go and implement and develop gender-responsive policies in its procurement practices. In respect of the issue of sexual harassment workshops, the department did report to the Commission that it conducted the trainings, but it failed to provide to the Commission what type of training, and also the data, disaggregated data indicating who attended. That is important because the Commission must be in a position to see that also managers are included in these trainings as the responsible people for implementing the mandate of the departments. And as highlighted in terms of the new Code of Good Practice 2022 in the handling of sexual harassment, the department had to review that policy. And the Commission recommended the department to be formally invited when the policy is being reviewed and when the workshops are being conducted. Further, in respect of the other recommendations, the department recommended the Commission recommended the department must complete and conduct the risk assessment on sexual harassment, bullying in the workplace, and submit it to the Commission. Also, what is key to note, Chair, is that in terms of the key performance areas, the Commission has been noting, as you will see with other entities, the key performance areas have not been highlighted or included for transformation. This will ensure that the managers are held accountable in respect of transformation. As such, the department in this instance did not have those key performance areas so that management and responsible persons can be held to account. And pursuant to the discussion or the hearing, the Commission required information to be submitted by the 30th of June 2023. As such, Chair, in respect of this Department of Small Business Development, the Commission did submit the information. It did appear before the Commission, and currently in this financial year, the Commission is in the process of evaluating information that is submitted, and it's drafting the progress of concerning this financial year, which will be tabled in Parliament at the end of the financial year. That is in respect of small business development. If we look into the Department of Water and Sanitation, it also appeared before the Commission. However, it failed to submit comprehensive and completed questionnaire with supporting documentation to the Commission, and it neglected then commitment to transformation practices. Due to lack of information, the Commission was not able to determine whether the working environment was conducive for men and women and persons with disability. As a result, the Commission noted that in its top and senior management position, they were predominantly occupied by Black women and Black men, almost to the exclusion of all racial groups. As highlighted, Chair, in terms of Section 20 of the Employment Equity Act, there should be designated employment equity managers who ensures that transformation is taking place, which the department was lacking. Further, the department did not have policies to deal with relevant issues, specifically those of gender and disability and issues facing the LGBTQI+ persons. And the department did not conduct sexual harassment workshops since 2018 to 2019, nor submitting its sexual harassment policy therein. The importance here, Chair, is that when sexual harassment workshops are conducted, they should be conducted on reviewed policies so that necessary protection that is advanced by the legislation should be afforded to the employees, and therefore lack of these workshops do not add to the contribution of conducive working environment. As indicated, detailed information was not provided. As a result, the Commission recommended that the full response should be submitted to the Commission. Part of the information that was required to augment the lack of information was the intervention by the department in addressing in respect of the sexual harassment policy, ensuring that it is within the workplace, it is utilized as well. And then the Commission recommended that the department should ensure that it targets also the senior and top management managers in its employment, so that they are also sensitized on these policies and through the sexual harassment workshops. Further, the department required to be provided with a plan that the training will address the imbalance between the perpetrator and the victim. Of most important, Chair, was the Commission required that the department should address and outline the process of legislative review in line with the Water Services Act to enable the Department of Water and Sanitation to issue directives to enforce compliance with drinking water quality. This comes at the backdrop, Chair, that the department's role in providing quality water to the inclusion of rural and remote areas is very crucial. Hence, the department recommended this. It's a part of the societal factors that the Commission always takes into account is the accessibility in respect of the services as important as the water services, as these they can be gender elements that are addressing here, leading to people traveling long distances to get quality water. And further, the department had to provide, among others, disciplinary processes it undertaking to discipline perpetrators of harassment and sexual harassment, also a gender responsive procurement programs that is being utilized. Including due to the lack of a person's representation of persons with disability, the department was recommended to consult internal and external stakeholders in sourcing and ensuring that the persons with disabilities are included and also are provided with reasonable accommodation. And further, the key performance areas had to be addressed so that the managers can have them and be in a position to be held accountable. And the Commission recommended the department had to conduct the sexual harassment workshop by the end of March 2023 and required the department to invite the commission. But at the end of March 2023, the commission was not invited yet. The department cited the reason that they were still reviewing the sexual harassment policy at that stage and were not yet in a position to roll out the workshops on sexual harassment. And pursuant to the hearing, Chair, there was then a follow-up that was conducted by the commission, and information was submitted in June 2023, and resulting from that, the commission continues during the current financial year as a form of a follow-up or progress of the department in implementing the recommendations of the commission. They appeared on the 14th of September 2023 to be more precise, and the further information was or is to be provided by the 30th of November, which is this month. And the commission will then evaluate the information that has been provided to see whether subsequent progress has been done. And the last entity in this report is Clover. Clover also appeared before the commission, and for over 5 years, Chair, Clover did not provide sexual harassment workshops in the workplace. This exacerbates the working environment that can be intimidating, harassing employees, and employees not being in a position to even know their rights. And as a private entity in this regard, the commission had to ensure that and recommended Clover to ensure that it is conducting these sexual harassment workshops, so that the private sector is also accounting and addressing conducive working environment. In respect of the representation of the previously disadvantaged groups, the junior and middle management levels, most of the employees were leaving the company. The commission was concerned and indicated that there was a duty to create an enabling working environment so that retention of previously disadvantaged people can also be achieved. And Clover was recommended to plan and ensure that it's understanding why previously disadvantaged persons were leaving, although it was highlighted in the employment equity plan of Clover, but Clover failed to ensure that it understands why previously disadvantaged persons are leaving the organization, meaning when they are leaving, it's leading again to progress being backwards instead, because conducive working environment is not there. Highlighting the aspect that the commission is not only concerned about the numbers, but also the conducive working environment. And if companies cannot ensure that they understand these reasons why employees are leaving, it then counters transformation. At the top and senior and also middle management, Clover had a representation of, it was dominated by white persons at over 50%. And in its response, it indicated that it has a difficulty of sourcing persons with disabilities. Its key performance areas did not require compliance with transformation legislation. In respect of the handling of sexual harassment cases by Clover, the commission observed that there was no timeline in handling of sexual harassment cases, which is a very important aspect in a process that expeditious handling is necessary, and without any timeline of handling, attending to complaints, victims may be left devastated or not attend their complaints not being addressed. And what the commission noted also was that when Clover reported and provided that it appointed an employment equity manager, its appointment was contradictory. It was not clear who can actually be held accountable between the Chief Executive Officer and the chairperson of Clover. And this finding will be detailed at the bottom and was in fact addressed by the Commission. So therefore, Chair, the recommendations that were made to Clover was that it must review its sexual harassment policy to ensure that it's in line with the 2022 Code of Good Practice. Importance to note is that this policy does not only deal with sexual harassment, it also deals with harassment in detail. It deals with bullying in the workplace and other forms of harassment that can be experienced through race, culture, and gender. And lack of these, ensuring that the policy complies with these policies, it's concerning, and hence the Commission recommended that it must be reviewed. And further, the Commission recommended it must expedite the handling of the cases. It also had to conduct workshops to senior managers upon the reviewing of the sexual harassment policy. In respect of the flexi time and the creation of a working conducive environment in general regarding its policies, the Commission recommended that several policies had to be reviewed and had to be put in place to ensure that the fathers and mothers are supported through the company, be it through its flexi working times or reasonable accommodation through its policies, so that the balance can be struck between responsibilities as a family members, including as work-related issues, as well as accommodating people in the workplace. The maternity policy had to be reviewed pursuant to recommendation of the Commission. As it was provided, it has different clauses to that of the pregnancy policy. That aspect was addressed to avoid any unnecessary or unintended consequences. So Clover, in its report, it indicated that it has put in place measures consulting employees that is in response to the recommendations of the Commission, particularly to the aspect why the employees were leaving. They had to employ some and review their policies to address retention. And in their interview processes, they now started using the means like exit interview processes as an additional means of ensuring that they are obtaining reasons to see how the previously disadvantaged persons can be retained. The company did have some programs in place. The one they call Mama Africa project, which was a good project which provided skills to women. And in its report, the Commission found the only negative aspect of it, it did not provide for any IT or information technology related skills to the women who are involved in these programs, which are meant to empower women. As such was recommended so that they can be empowered through these programs. Further, the Commission recommended Clover to ensure that it's consulting different organizations for the inclusion of persons with disability. And as previously indicated with other institutions, this was the first appearance before the Commission. During the current financial year, it was engaged, the entity also by the Commission. It appeared also on the 14th of September, and the Commission is in the process of evaluating information submitted. Chair, I will conclude with the last report that update was required on. The report is titled The Progress on Transformation in the Public and Private Sector. This report now details the progress that was made from the previous financial year. Companies that appeared is ArcelorMittal, Stock, Vosta Architects, and Sunparks, also Department of Forestry, Fisheries, and Environment. Upon the conducting of the hearing, the entities appeared before the commission. We will start with ArcelorMittal. This company was engaged, and the commission observed that it made substantial efforts to ensure that its policies reflect its intention regarding gender transformation. The ArcelorMittal, it provided some bursaries and programs that reflect the promising efforts, as most of the recipients of the bursaries were African, colored, and Indians, and women represent a smaller percentage of recipients, of which seeks to address the difficulty of attracting women in the center. The ArcelorMittal indicated that given the nature of its sector in the steel industry, it was finding difficulties to get skilled and in its pipeline to ensure that women are also benefiting in its programs and are represented in its sector. And hence, from its presentation, a lot of its information, the beneficiary shows that more men are the ones who actually benefited. And as highlighted, the ArcelorMittal indicated that it had difficulty to transform due to lack of skills, especially particularly from women in the industry, and hence it's feeding to lack of fair representation. However, it did indicate that it now has brought various programs in place, and various programs that are meant to ensure that women are developed, and also plans are in place to ensure that women are empowered in order to occupy senior positions. Part of the programs that were indicated there, Chair, it's among others, the group leadership programs, which is meant to transition and the women in its employment to senior management position. There's also mentoring programs that are navigating careers and skills development for ongoing support. And also there's respective forums and learning paths that are in place as detailed in the report, Chair. So those are some of the measures that, to the observation of the commission, there were some strides and programs in place to try and address the defect that women are not skilled and are not represented in the sector. And therefore, as a continuous exercise, Chair, also ArcelorMittal, following the progress, because this was now a follow-up on the progress of the entity. The view of the commission is that the transformation is a continuous progress, and the commission will continue to monitor these entities so that we see the developments, because be it as it may that policies are in place, the problem is that when they are not implemented and are not feeding to the transformation, we will only be working backwards, Chair. So therefore, we are looking forward, if there was impact, to keep on monitoring and see in the upcoming financial years whether there is now impact on these policies that were recommended by the Commission, they were put in place so that we can see the transformation is going forward. And with the respect to Storch Vosta Architects, SVA, it also appeared before the Commission. From evaluation of its information, it shows that it did have willingness to commit to transformation. However, it was not performing good in respect of representation of women and persons with disability. And the company indicated its obstacles in respect of the question why when it had identified 2 women that should be advanced in its executive levels, but upon identifying the two women, it was unable to ensure that they are promoted accordingly because there was a restructuring and retrenchment process that was taking place. These are some of the challenges that the Commission is facing regarding its progress or intended achievement. Some of the factors that may be beyond the control of the Commission and that of companies like retrenchment, which is a different process by other departments, they can affect transformation. In respect further, the company undertook that although the retrenchment affected it at that time, when it reaches its profitability stages, it will then reconsider its intentions to ensure that women are represented in its employment. Therefore, Chair, as a continuous exercise, the Commission will continue in the monitoring this so that to see if indeed these undertakings are implemented when the company starts to be profitable. In respect of the additional measures, the company did provide additional measures to the Commission that it has. Among others, it revised its maternity leave policy, sexual harassment policy. It further revised its provided training on bullying in order to create conducive working environment. And the last of the departments, Chair, that appeared in this report is the Department of Forestry, Fisheries, and Environment. In fact, the second last, Chair, but I won't be long in this respect. The Commission engaged this department as well. What it observed from the evaluating the information that was submitted is that there was significant strides that the department, and it shows willingness to commit to transformation in the workplace. However, the racial representation was more of a challenge to it. As you note, Chair, that in respect of transformation, elements such as gender, race, and they play a role. And at times when companies try to balance one side, it's struggling on the other. Hence, the Commission will always make recommendations to try and ensure that the balance has been struck. An example would be when a Black woman is maybe promoted in a position, it creates them a vacancy on the other, and the company has to see that it's either replacing a Black or certain race in order to try and keep a fair representation. In respect of the LGBTQI plus A plus persons and persons with disability, it was concerning, Chair, that the policies are lacking addressing the needs of these persons, and the Commission continuously engaged this department to bring these policies in place. And in fact, the reviewed and developed policies were submitted. And in respect of the support that the company is giving to the Employment Equity Manager, Chair, it was concerning that the manager was not given sufficient support pursuant to evaluation of the Commission, and lack of support from executive management to employment equity managers counters transformation, and it does not assist in ensuring that responsibilities are carried, in ensuring that the employment equity plans are in place, they are also enforced. Therefore, if there is no support, we can have all the policies that are there with good intentions, but they end up being no implementation because of lack of support from executive managers. Further, the Commission recommended that the policies should be reviewed, all of its policies that were outdated, and they were provided to the Commission. Programs and policies in respect of persons with disabilities and LGBTIQA plus persons were also submitted. The Commission is therefore in a process of evaluating the information that has been provided. The essence is that, Chair, if there is no implementation, it is a problem. Hence, this is a continuous exercise. Last is the South African national parks of the entities that appeared. The South African national parks also appeared, Chair. It did show willingness and commitment to transform in the workplace as per the report that was published. However, the racial representation and persons with disability at SANParks remained a concern. And SANParks reviewed its policies and submitted them to the Commission in line with the Commission's recommendations. This is pursuant to the Commission finding that a lot of its employment policies were not reviewed. They were reviewed a long time ago. They were not relevant with the relevant. They were not in accordance with the current applicable legislation. The essence of policies to be in place, Chair, is the issue of creating a conducive working environment for everyone in the employment. And hence, this is an important issue and the Commission recommended such. And one aspect to highlight, Chair, is that during the hearing of 2021-2022, the Commission noted there was a case that was reported there at the SANParks, whereby it was indicated that the senior manager allegedly harassed the employee. There was some investigation from the reports to the Commission that there was a finding and there was an appointment of some private law firms to handle the matter, which concluded investigation that there was no other prospects of success or prima facie case so that the case can be taken further. And the Commission then noted as a result, the victim actually ended up resigning. And these type of environments are caused particularly by the fact that emphasis, if it's not placed on the review of the sexual harassment policies, it's then counters transformation because employees must be aware that the policies are in place and are meant to protect them. Specifically, these entities did not show that how are managers also held accountable, especially where the policy requires managers to be the ones responsible for handling of the sexual harassment cases. But then it lacked addressing the issues that are detailed in the updated sexual harassment code of good practice. And as a result, the working environment end up not being addressed, resulting in such observations that people end up leaving the workplace due to, among others, that cases maybe could have not been handled accordingly. As such, Chair, as with other entities, implementation is an emphasis of the Commission that if it is not done, it becomes then a challenge that comes when the Commission is monitoring again progress of these entities 2-3 years down the line. We may find that implementation is not progressing. A general observation, Chair, is that in respect of both the reports that are presented to before the portfolio committee today, is that in general, the private sector and public sector entities, they came and indicated they experienced major setbacks in respect of transformation. And the findings on the recommendations of the Commission were made in order to try and assist them in ensuring that they are transforming. You would have noted in the presentation, different reasons were given. And one entity performs good on one element, the other performs bad on the next element, and so on. And hence, it's creating that difficulty for these entities to, or for the conducive working environment. However, the Commission, through its recommendations, is continuously addressing these shortcomings. The issue of these outdated sexual harassment policies, Chair, has been, in fact, a lot of these entities did not have the policies at all. And not only with these entities that are presented today, but throughout the transformation hearings that the Commission has been conducting. Under correction, it will be under a percent that had policies in place, and a lot of them were outdated, therefore not creating a conducive working environment. Similarly, sexual harassment training workshops in the workplace were not conducted. It was concerning that a lot of companies would not conduct them for more than 5 years, meaning that the environment would not transform and would not be suitable for men and women and persons with disabilities in the workplace. In respect of the procurement practices, Chair, that is just before the new regulations on procurement, the Commission also observed that a lot of companies were reluctant to address the issues of broad-based Black economic empowerment and preferential procurement, which these legislations intend to advance persons, previously disadvantaged persons. In evaluation of these practices, procurement practices, the Commission found in general that these entities were not willing to ensure that women and men are also included and previously disadvantaged persons are included in their procurement practices. Most importantly, also, where they indicate that there is some procurement, it will be found, Chair, that in terms of the numbers, they would report, for an example, that out of 10 tenders, there was one which was awarded to men and 9 to women, which may, in hindsight, look like there is movement, only to find that actually one which was awarded in monetary value is 100 billion. And now the rest of the 9 that was awarded is just about 1 million, meaning that transformation is continuous, Chair. And through these procurement practices, it has been difficult the companies have been showing reluctance and slow progress to develop them. We do note the developments and challenges that this legislation has been facing in different courts of laws regarding the aspects of indicating that quota system, applying the quota system in the workplace. We believe the courts, as these matters continues, will continue to address the issue of procurement. Essence to highlight, Chair, that these legislations were just brought for the very same purpose of advancing this. And we find these companies end up challenging these type of provisions. However, our continuous units, such as the monitoring of the Parliament, of the legislation that are released, the Commission continues to evaluate those policies and see that the issue of empowerment is there, and it's not only about the number. A number can be a starting progress, but the aspect or the essence is regarding the conducive working environment. Therefore, Chair, pursuant to the hearings and evidence that has been submitted, in general, the Commission can say that there was a strides toward addressing transformation that the Commission observed, and that their entities did show their willingness, although there was a slow improvement towards the trajectory of transformation. Thank you, Chair. That concludes the presentation.
Thank you. Advocate, any additions or?
No, nothing from our side except that the two presenters will indicate to us when they would like us to come in during question time. It's myself and Dr. Matatoka has joined us, so yeah, we will support, but they've got it.
Okay. No, thank you. Honorable members, those are the presentations that have been tabled in front of us. I will then take questions. And if members are unable to, have got challenge with their gadgets, they can indicate. By the rules, there are no questions. If there's somebody, Honorable Mdabe. Honorable
Is-
Mkondo.
Yes, Chair.
Okay. Okay. Honorable Dabe.
Thank you, Chair, and thanks to the CGE for the comprehensive presentation, well informed in terms of where we are the transformation. Our first question is the collaborative working environment between the CGE and the Department of Employment and Labor, with its entities as well. More specifically, NEDLAC. The issue of the social partners, whether CGE has had an opportunity to engage issue of a transformation as a subject in the project. Two, the rate at which gender-based violence is not only in the society but in the working environment. To be more specific on the issue of sexual harassment policies, lack and development, has there been an area that requires, firstly, the issue of gaps that have been identified in the legislative environment, whereby the social partners, with the lack of having these policies, does therefore then the current law or policies that we have has some gaps which need our attention. The second question, the second question is in relation to whether the Commission Act does have teeth for non-compliance, or are there any consequences for the non-compliant or breach thereof that they would have to deal with if ever there is a gap as well on that, which they have identified in the legislative environment. Thank you, Chair.
Thank you. Honorable Mkondo.
Thanks, Chair. Chair, I will also join Honorable Mdabe to welcome the
Over to you.
presentation. Can you hear me, Chair?
Yes, we can hear you.
Yes, Chair. Thank you. Chair, my question is, we all know that the legislatures, that is Parliament, provincial legislatures and municipalities, are dominated by men due to political parties, specifically the small ones, that are having 2 or 1 members, and they all decide to bring men to Parliament and the legislatures and municipalities. I just want to know if the CGE had ever had any engagement with the IEC in that regard, and if not, maybe is there any envisaged engagement with the IEC? Because as we are moving to the 2024 elections, we will be faced with the independent candidates. And to me, it's just a strategy of men wanting to dominate that space. So how is CGE going to deal with that phenomenon come 2024 elections together with the IEC? Thanks, Chair.
Thank you. Those are the questions. I just want to check if are there any other hands. Okay, so it was Honorable Mdabe and Honorable. Okay. Thank you. Can we then get a response?
Thank you, Chair. Tsietsi, can you take the questions, please?
Thank you, Chair. In respect of the questions from Honorable Ndabe, I would the Chair give the question to, if you may allow to give the question to the acting CEO to address the two of the questions. However, I would address the two questions as well. There were 4 questions. In respect of the question of whether the CGE Act or legislation has the necessary powers to ensure that implementation with its recommendations are adhered to. Indeed, yes, the Commission does have the enabling legislation and its provisions, articulated powers, and that are under Section 18 of the Commission for Gender Equality Act. And in fact, Honorable Chair, where the entities are disputing or are not having issues regarding the report of the Commission, they are at liberty to, in respect of the legal processes, to take the Commission to court in order to review the report of the Commission. That is one aspect that is at their liberty. And in respect of enforcement, Chair, from the reports that we have been issuing, as highlighted, entities will actually perform well. The process is always that there would be a new hearing made by the follow-up hearing. And a follow-up hearing will then inform the Commission whether in terms of the progress that has been made following the first recommendations, that's where the Commission ordinarily will take into consideration whether there is a need to then refer the matter to court. And from the reports that we have been having, that is not the challenge that we have experienced. A lot of entities from these reports actually did provide their response in that regard and progress, whereby it did not necessitate the Commission to take the matter further. The challenges that were cited, Chair, it's among others where there would be like a form of a stagnant position, is where companies restructure and or companies closes up, or those type of circumstances then result in the company not being in a position to then fully comply with the recommendation. For an example, if one recommendation was outstanding. So in conclusion, we do have powers, Chair, to take our recommendations to court, and will do so as we are going through our reports. And further, in respect of the scourge of gender-based violence in the country that we are facing, and that are particularly coming out in the workplace as well, the Commission does have various, also in addition to the legal departments, the education and research department, and always explores the different means of providing education and awareness regarding gender-based violence. And through its recommendations, actually, Commission achieved, in our view, in respect of ensuring that these companies bring policies in place, like we cited, the policies on the handling of gender-based violence in the workplace and sexual harassment in the workplace. And from all the entities that we required, that these policies were implemented. And cases were also reported to the Commission regarding how the matters were handled. And from that, the Commission made recommendations regarding some of the handling of the cases, which resulted in some of the cases being reheard properly, so that the policies can have a room to apply and protection can be given. And on my side, I will then allow I think the one question from Honorable Mkonto, it's regarding the elections. I think the Chair will be in a more position to address that one as for our future endeavors in that regard. Thank you, Chair.
Chairperson?
Yes, you can go ahead.
All right. Thank you, Chairperson. Good afternoon, Chairperson, honorable members. The question around the collaboration between the CGE and the Department of Employment and Labor and NEDLAC. What we used to do in the past, we used to invite the Department of Employment and Labor to come and observe our proceedings. And in their presence, Chairperson, they were able to provide us with their insights around the Employment Equity Act and the areas that they focus on. But then we also appreciated that we seem to be approaching it from a different angle altogether, wherein CGE is focusing more on the enabling environment, and they are also looking at perhaps the number of representation of the previously disadvantaged groups at various occupational levels. But I agree, Honorable Member, that then there's that room to say CGE is the way in which you can work with the Department of Labor without necessarily compromising your independency as a Chapter 9 institutions around that. But it's something that we are able to consider going forward together with NEDLAC. We take the advice. In fact, as we're planning this engagement 2 weeks back with the chairperson of the CGE. This is one of the strategic meetings that we are planning to take our transformation hearings to another level with key and like-minded institutions. I just want to add a bit also on the question around GBV. I think the honorable member also asked the question of whether is there a gap in terms of legislation. You will recall, honorable member, that under the Domestic Violence Act, the act specifically confined protection orders when persons were in a domestic relationship. And when you are not in a domestic relationship and you are in the workplace, you are not able to necessarily get the protection orders under the Domestic Violence Act of 1998. But then you have the Protection from Harassment Act that was then introduced and used as an empowering provision to provide relief for those that were not in domestic relationships. But because there was not a proper understanding of the relationship between the then Domestic Violence Act of 1998 and the Protection of Harassment Act, it meant that the violence that happened within the workplace, it left a lot of employees without the necessary relief. Because when they go to the police station, for example, you'll be told that you're not in a domestic relationship, therefore you cannot get a protection order. But it's from this premise that, Honorable Member, we welcome the GBV bills that have been amended so that the issue of domestic relationship can be addressed. And more broadly, when we look at the code itself, where it talks about harassment, it talks about bullying, it also touches on those areas where ordinarily or before they were not catered to. So currently now, employees in the workplace can use the current legislation to get the necessary relief without finding any challenges with the subs station. But that also does not take away the responsibility of the employer to put the protective measures in place to align their practices, their policies with the code of good practice when it comes to harassment and bullying and intimidation within the workplace. Just to say also, as far as the CG Act is concerned, the question is also around, is there a legislative gap on our side? Chairperson, we've commenced a review process of our legislation as well. And we have observed internally also that, yes, we are able to implement the recommendations of the CGE. But now, when we look at the kind of developments that we've been dealing with, we've picked up a certain gap also. When we consider the remedial actions that, for example, the Office of the Public Protector has. So we've started a process internally of consultation. We'll be consulting also external stakeholders around the possible amendment of the CG Act to strengthen the already existing teeth within the Act so that we can have a more impact going forward, not just only from the transformation hearings, but also other projects that are embarked on by the research department, the public education as well, because we encounter challenges there as well, for example, with municipalities not adhering to our gender audit tool, amongst others. So we are currently embarking on that internal process to make sure that we strengthen areas that we think needs to be strengthened from our side. Chairperson, I'll hand over to the IEC question. Thank you, Chair.
Thank you, Chair. Just in terms of the IEC question, we earlier this year had a multi-party consultation process with several political parties, specifically the women caucuses of those political parties, to come and talk about exactly this issue that we are raising, because we are finding that political parties tend to bring on board women as support or as strategic partners rather than as real partners. So far, the only political party that has got in its policies the issue of 50-50 is the African National Congress. All others do not have it in writing, although a lot of them would say they aspire towards working towards that. But we are monitoring and we are working to, we are pushing them to actually pronounce on that. We find that even the positioning of women inside the parties is usually not seen as critical in terms of equality, but rather as critical in terms of strategy, where political parties feel we want to go to rural areas, the women in the rural areas, then they will bring a face of a woman who belongs to the rural areas. They want the white housewife, sometimes they will bring that face, but it is never about this is a formidable leader. We would like to be seen to be led by this leader, which is unfortunate. And I think the most unfortunate thing is the IEC itself cannot interfere to that extent, because the IEC is supposed to be seen to be independent and therefore slightly distant when it oversees the elections. And once it comes in to say, you know, how about you do this? How about you do that? People will turn around and say, we lost because the IEC said we need to bring women on board. And we had a formula where we were focusing particularly on conservative communities, etc. So I think it must be incumbent on political parties, but what we are also doing as the CGE, as we are traversing the country, is to say to each and every one of them, both individual and juristic persons in this country, that they are subject to our oversight powers. So we do have those powers, and we try as much as possible to exercise them, and we will push towards that. But I think it's more our duty than IEC, as and Human Rights Commission and others than IEC. So that's where we need to help the IEC there. Thank you. Thank you, Chair.
Thank you, Advocate. By the looks, there are no follow-up questions. We'll thank you for the presentation, which is more empowering. I would have loved to have the same number of private sector organizations that have some challenges, or maybe they are workers there have not reported some of these issues that we have been highlighted in terms of sexual harassment, which in that goes with gender-based violence and other people with people with the people with disabilities, because in my view, I would like that balance be exposed so that you don't get a private sector. Private sector at times run away with murder, if I can use that term, in some of the areas of transformation in particular. But I'm happy that you have also raised the weaknesses in some of in our departments, which we will follow up. And pardon me my ignorance in the question that I'm going to ask, that do you go out and what I will say, do an oversight to companies, or do you wait for people to complain, for complaints to be submitted to your company, I mean to your institution? If that can be clarified, so that we are able to have a balanced understanding, whether you do go out and inspect, or it will depend on the unemployment and labor, if I can cite one, because it's that department that has got inspectors in their department. If I can just get that clarity, that's why I said that you'll pardon my ignorance on that.
Thank you, Chair. We do not wait for for complaints. In fact, all the departments and private companies that we have approached, we approached as a result of our own processes, saying, let's go for a medium company, let's go for a big company, let's look at the mining sector, in a random but controlled fashion. However, we do get complaints from people that we also follow up. But this oversight that we're doing, government departments and private sector, is not based on complaints at all, because we are alive to the fact that sometimes the culture in the organization is very oppressive to people going out to raise issues. So we are proactive in that regard.
Oh, okay. No, thank you very much. Thank you very much. We will at an appropriate time, we'll request maybe those that you have visited in terms of private sector, because I do see that you have Glover is one of the companies, but there are some other big companies where women came into the space. I can cite one, motor car manufacturing industries, companies that are there that now are more exposed to women coming into the for mining, for that matter. If then we will request you, if possible, to just forward, not now, forward that what we have picked up, whether 2 or 3 in the private sector, if it is possible. We will also, through you, interact with your office advocate in terms of what then the departments, including this one of ours, what are the improvements that are there in terms of transformation, which transformation is not only about numbers. Transformation is really to see if departments are really taking it serious. I'm raising this because I'm a bit concerned about the outdated policies that are there in some of them. So we will request that information either in writing, or if necessary, have a follow-up, a meeting where we will then want to check if Department of Small Business, if they are really engaged more in transformation, but not only the Department of the Small Business. There are those that are in the social economic ones, which is what? Education, health, police, what is it? Defense, science and higher education, science and technology. If you just have time and circulate that to us through our committee secretary, Mr. Sakaza, so that we are able to trace and see. Remember, we'll be listening to departments, time to listen to departments making a debate, presenting a report. And if my memory serves me well, very few are highlighting the issues of transformation, which it's a very important struggle, because a transformation struggle is a very difficult struggle. And I think we are not going to run away from that this is a struggle, and a struggle that we are not going to be apologetic about, a struggle that we are to intensify, not for the benefit of the committee, and nor a benefit for a particular political party, but for the benefit of the country as a whole. And thank you very much, Advocate. We will interact with you through our secretariat, and we will then release you, and until we meet again with you through an invitation. We will release you now, and members will remain so that we deal with our house, our in-house programs. Thank you very much.
Okay. Thank you very much for the opportunity, Chairperson. Thank you to all the honorables. We appreciate it. Thanks.
Thank you.
Bye.
Thank you. Mr. Sakaza, as they are leaving, can you please, you know that we are also to deal with minutes. I hope you have prepared for that. There are our minutes, honorable members. The 7th of May, 2023, which was our minutes on the study tour to Kenya. Okay, the attendance. Okay, that's page 1, page 2. Thank you. Can we get a formal mover? Is there any? Can we get a formal mover of that set of?
Sibusiso
Minute.
Mdabe, Chair.
Honorable Mdabe.
Sibusiso
Honorable
Mdabe,
Mdabe. Yes,
I,
Honorable Mdabe.
Sibusiso Mdabe, formally move for the adoption of the minutes of the 7th of May, 2023.
Thank you. Can we get a seconder? Can we get a seconder, honorable members? Seconder, Mzolani.
Chair,
Honorable Mkondo.
I Nonhlanhla Mkhonto second the move for the adoption of the minutes. Thanks, Chair.
Thank you. Can we get in Mr. Sakaza? Oh. The minutes of the 24th of May. Mr. Sakaza, can you, yes? That is the attendance of members. Staff and the department. Those are the minutes, honorable members. Can we get a mover?
Sibusiso Mdabe, Chair.
Honorable Mdabe.
I, Sibusiso Mdabe, formally move for the adoption of the minutes of the 24th of May, 2023.
Thank you. Can we get a formal seconder?
I Nonhlanhla Mkhonto second the
Yes.
move for the adoption of the minutes of the 24th of May, 2023.
Thank you, honorable members. Can we get the next set of minutes, honorable? I'm sorry, Mr. Sakaza. Mr. Sakaza. Zolan. Is Mr. Sakaza still with us? What's happening now? Oshia, can you please check Mr. Sakaza?
Hello, Chair. I will do so now, Chair. Thanks.
They have both, what, I don't know, I don't want to say they've both disappeared. Have you managed to get hold of him, Mr. Ndabeni?
Hello, Chair. I'm speaking to him on the other line. He's trying to flight the correct minutes, Chair.
What do you mean correct? Why didn't he sort them out? I will. I'm of the understanding that they've sorted them out now. No, aware that which one is coming.
Chair, I'm sorry, it's coming there. Sorry.
The Department of Employment and Labour on non-submission of annual report of UIF in Parliament, which was on the 31st of May. Thank you. Can we get a formal mover?
Chair,
Yes, Honorable Mkondo.
I, Nonhlanhla Mkondo, move for the adoption of the minutes of the 31st of May 2023.
Thank you. Can we get a seconder? A formal seconder? Is Honorable Nonzela around? Can we get a formal seconder? Okay, that we can get a seconder because it, can you take us back to the, can you scroll, can you go back to the attendance? Honorable, I'm sorry, Mr. Sakas. Zolani, I just want to see who was present. What I know it was Honorable Mkondo, Honorable Nonzele. Am I allowed to second? Am I allowed to second?
Yes, Chair. Yes, Chair, you can second, you were there.
I, Mary Ann Lindela Dunjwa, formally second the Honorable Mkondo, the meeting of the minutes being the true reflection of the minute of the meeting. of the 31st of May. Can you flight the next set of minutes? Silinde wena ke Mr. Sakasa. Minutes of 21st of June, non-submission by the compensation fund. Yes. Thank you, Mr. Sakasa. Can we get a formal mover?
Honorable Chairperson, Honorable Zuma, I formally move the adoption of the report.
If my memory serves me well, you were absent. There's an apology. Can we go to, just to check if I'm correct in terms of Honorable Zuma? Just hold on. Yes. Honorable Zuma was not part of the meeting. Unfortunately, he can't move for the acceptance of the report. Uyela Paya, also that I remember since Okwazo's guide. Those are the apologies were from Honorable Kato. Then the rest were Tunjwa, Makubela, Nunzaire Volmaras, Honorable Begrem, Legoff, Honorable Mkondo, Honorable Dena, Honorable Ngobo. Those are the members that were present. Then the apologies are starting and the absence. So unfortunately, Honorable Zuma, you can move for those minutes. Any of those that are above, starting from IFB right up. Can we get a mover?
Chair,
Honorable Mkondo.
I Nonhlanhla Mkhonto move for the adoption of the minutes.
Can we get a seconder? I, Mary Ann Lindelwa Tunjwa. Second, Honorable Mkondo, on the acceptance of the minutes. Can we get another set?
That was the last one, Chair, for this. There were only 4.
Thank you very much. Thank you very much, honorable members. We have come the last item on our program, to remind the members that on the 10th, which is on Friday, we will then be tabling our study tour, or in terms of the program, and those that were, just to remind so that members are aware. It will be, I think it will be mini plenaries on the 10th of this month, which is Friday. Having said that, I will request members to stand. That was only like 10 minutes. Thank you very much, honorable members. Our meeting stand adjourned until we meet on Friday.
Thank you, Madam Chair.
Thank you.
Thank you, Chair. We are already standing, waiting for the maize to leave chamber.
Thank you, Madam Chairperson.
Thank you. Thank you. Bye.